Good afternoon, everyone. Today we will analyze the case in the Li Yuwen case. And the partner in this case are plaintiff Li Yirui and the first defendant Li Kai-wei, the second defendant Li Nanghao, and the third defendant Qi Yiper.
And the first defendant and the plaintiff are brothers and sister. The second defendant is the mother of the plaintiff and the first defendant. The plaintiff and the first defendant are the shareholders of the third defendant companies respectively. After their father died, they hold 54.5% and 45.5% shares respectively. The plaintiff is the largest shareholder.
And the situation of this case is roughly as follows. The first and the second defendant should jointly pay the third defendant 3 million ringgit, but correct, this is more than the funds wrong heard by the first and second defendant. So the third defendant appointed that the second defendant as a company director.
And according to the section 340 of the Company Act 2016, the third defendant shall convene the extraordinary general meeting within 40 days of the occurrence of the event. And it was announced that the first defendant and the second defendant would jointly compensate the plaintiff for damage and remove the first defendant from being a director of the third defendant company and appointing the plaintiff as a director of the company.
However, in the Alex 7, in the relief sought by the plaintiff is a derivative lawsuit, and the plaintiff is not eligible to initiate such a lawsuit because the right to obtain relief belongs to the company. The plaintiff needs to permission of the company if they want to file the lawsuit.
Plaintiff responded in Crucial 71. It is primarily an oppression act filed under Section 346 of the Companies Act 2016, where leave is not required, not objection from the plaintiff. The plaintiff said, so because of the defendant's three acts, one is misappropriation of funds. Two is appointment of the second defendant as a director of the third defendant company. Three is failure to convene a general meeting of shareholders in the time.
The defendant's response was that the prohibit the cycle then did not appear, and the plaintiff could not use this to evade legal responsibility. Stop does not arise, and that plaintiff can not reply on it invade compliance with the dominant provision, not delay, and it has reserved its right to opt the OS on the procedural and substantive ground.
There are some different views on the views of both parties. The mere fact that the same set of the circumstances might additionally support the derivative action is no different to the Oppression Act. This was the opposition in the reconcile Samuel.
On the other hand, requires under subsection 1 and the finding of operation or disregard, and then leave to the count with discretion and to the relief which it may grant, including among the options that of winding the company up. If a case of operational or disregard is made out, the section applies, and it is no answer to say that relief may also have been obtained in the minority shareholder action.
But others believe that um, misappropriation of fundings is an act of the operation, and there is already evidence that the fundings belong to the first defendant have been misappropriated. Accused individuals or collectives misappropriate fundings, which is a malicious act of the oppression against a few people. This behavior seriously damages the interest of the company members.
And the count hold that although these views were reasonable, the count unlimited perfect the defendant's view. The plaintiff feared legal loss and the compensation sought should be student.
According to the example of the force, first, uh, as an dependent legal entity, when the company suffered loss or make mistakes, the plaintiff should be a company itself. To give an example, a company's stock has fallen, which means that the company has suffered a loss. The shareholder cannot ask the company to compensate him because the shares of the company he's interested in for. He still hold all the share in his own absolutely unencumbered property.
The company is an independent legal person that bears limited consequence and exercise limited rights. The company is reliable for its contracts and terms. The shareholder has no such reliability. The company's acquire cause of action for breach of contract and for tort which damage the company. Therefore, shareholders have no ground for litigation. Therefore, when the company suffers loss, only the company can claim to sue.
Of course, unless the company violates its corresponding obligations and cause loss to the company and the shareholders. Shareholders can bring a lawsuit. The loss of shareholders, such as reduction of the shareholding value and the loss of dividends, only reflect the loss suffered by the company, and the company has its own reasons for uh, litigation. If shareholders are allowed to recover such loss, the defendant will bear double the recovery expense. This is not allowed because it will harm the interest of the company's debtor.
And the derivative litigation and the operative litigation are not mutually exclusive, and there may be situations that target both derivative litigation and operative litigation. And I will introduce you to the difference between derivative litigation and the operative litigation. The essential difference lies minorate operation petition deal with action by the minority controls, where the companies cannot be petitioner and is only nominal defendant. And by the contrast, a derivative action is brought by a minority shareholder for and on behalf of the company to deal with the wrong done to the company and for the benefit of this company to recover for the company as bit off from the company. So my conclusion is that oppressive litigation tends to cause loss to the minority shareholder when the company is a loss, and derivative litigation tends to cause the minority shareholder to make up for the loss through litigation when the company is not at fault.
Finally, the Singapore court heard the case. The following members are studied. Mm, The first one is, what is the real injury that the plaintiff seek to vindicate? And is that injury distinct from the injury to the company? And does it amount to commercial unfairness against the plaintiff? And what is the essential remedy that is being sought? And it is a remedy that meaningfully vindicate the real injury that the plaintiff has suffered.
Mm, Put all these case and the analysis framework to the fact of includes one, the injured was suffered by the third defendant company for which the remanded in the play 1 and B are claimed by the plaintiff for the third defendant company. The plaintiff suffered no action for injury in her personal capacity, but claims remained for the third defendant company.
Final judgment of the course, it is an abuse of the process to have commenced suit in which remanded are claimed for the third defendant companies without a proof and the sanction of the court according to section 347 and 350 of the Company Act 2616.
Finally, and the inclusion, we can learn from this case. When we was damaged by others, we should know the count judging by the procedure, analyze procedure. And first is injury, second is remedial measure. And when we are managing the company, we should pay practical attention to the change in the company equal to reduce the company illegal operation, lead to the loss of self-interest, which will help reduce our own risk. When such case occur, we should clarify the meaning of the company as the legal entire, analyze the difference between oppressive litigation and derivative litigation, and protect our own interests to the greatest extent.
I would like to make a personal point too. Most people think that the company is just a social organization composed of the people and managed by the people. This is mainly engaged in some production and business activities. However, in legal practice, the company is actually an independent entity and can be regarded as an ordinary person. Companies, like people, have a independent personality and have a ability to bear responsibilities and enjoy rights conferred by law. That means in the face of dispute, the company is fully qualified to become an independent civil subject with rights and obligations. So I think in this example, when the company suffered the loss, the lawsuit conducted only by the plaintiff as a shareholder is not only inconsistent with the sorry with the legal procedure, but also violate the right of the company as an independent legal person.
And after analyze, we grab some keyword and company as the legal entire and oppressive litigation, derivative litigation, and after this, this is all we learn from this case. That's all. Thank you for listening.